Good morning.
Good morning.
And there's two appeals here. They were consolidated for record purposes and they're traveling together. Do you need to argue? Can you argue them together?
I can, Your Honor.
Okay, is that all right with you, Mr. Wade?
It is, Your Honor. Thank you.
Okay, all right. Thank you both. Then you can proceed when you're ready, Mr. Crawford.
Judge LaRose, Judge Kelly, Judge Rothstein-Yoakum, good morning. My name is Andrew Crawford. I'm here on behalf of the appellants in this case, Betty Barisic and Rada Barisic. This case comes to this court and from the Circuit Court in Fort Pinellas County after the denial of an injunction for protection against stalking. Judge Kelly, before I go further, I'd respectfully ask for 5 minutes of rebuttal.
All right.
This was a very extensive case that was presented over a 2-day time period, 9 hours, with 8 different witnesses, including 2 expert witnesses. Only one witness testified on behalf of the appellee in this case. The overwhelming evidence demonstrated that the appellee, Beth Frost, was upset about a fence that was located on the Barisic property. In response to that, she tore down the fence and basically waged what was referred to below as a chemical warfare, which she would continually spray chemicals over the fence, dump chemicals over the fence below the Barisic bedroom window. And numerous witnesses testified after seeing this toxic mist come over the fence that they would become incredibly ill. In addition to the witness testimony, there was numerous photographs, numerous videos. There was a report from the Florida Department of Agriculture demonstrating that what Ms. Frost was dumping over the fence was indeed insecticide, as well as mothballs.
Did someone testify that they actually saw her spraying these chemicals?
Absolutely, they did. Absolutely.
Okay, which witnesses testified that they saw her spray them?
Tina Barisic, the sister, as well as the appellant, Betty Barisic. Additionally, there was another witness, the son-in-law, Mr. Schofield, who testified that he actually saw Miss Frost walking back and forth. He would then notice a white mist and chemical odor. He would become extremely ill. He would be sick for days despite wearing protective equipment. And furthermore, not only was his testimony confirmed by those 2 witnesses, but also the Florida Department of Agriculture's report, which is contained there in the record, as well as the medical evidence, which was submitted through Ms. Barisic, and the chemical results of a medical screening that she had, which demonstrated the presence of extremely high levels of pesticides, glyphosate, which is a chemical found in Roundup, as well as other chemicals which are carcinogens. So not only do you have the direct testimony, Judge Rothstein-Yoakum, but you actually have medical evidence that was introduced. You also have a Department of Agriculture report who's got no dog in the fight, who came out and specifically tested soil samples from the north of the Barisic property, which contained 2 different insecticides as well as mothballs.
Mr. Crawford, I thought the trial judge hinted at or suggested that this might not necessarily be stalking as the statute defines it, but it could be viewed as a nuisance. And I'm just wondering if you sought the wrong remedy.
That is not, well, Judge LaRose, in this particular case, as the court knows, stalking is a repeated course of conduct directed at a particular person that serves no legitimate purpose and constitutes harassment. In this case, you not only have the chemical spraying, which is not just on her property, but over the fence. You have lewd gestures. You have repeated profanity. You have repeated trespassing. You have repeated dumping of chemicals under the Barisic's bedroom windows. You have chemicals that are thrown on their car, which causes the paint to wear off. I'd submit to the...
You're making a lot of assumptions, right, Mr. Crawford? That
I am not.
You,
no, ma'am,
you are assuming that the trial court found the witnesses credible in regards to the chemicals being sprayed under the windows or thrown on the car. And I think the trial court made it pretty clear that it didn't believe that happened. So and obviously we can't revisit that. So taking that as, you know, I understand you're trying to present the facts in the light most favorable to your client, but the trial court already rejected that. So in the light most, given what we've got, what's the best case that you can make for your client without asking us to revisit the trial court's credibility determinations?
Judge Rothstein-Yoakum, I am not asking the court to reweight credibility because that's not something I can do on direct appeal. The standard of review here is de novo based on the trial court's rulings. Even if it's not de novo, her factual findings are not supported by clear, the competent substantial evidence standard. Even in the facts most favorable to Mr. Wade and to the appellee in this case, I would submit that the trial court's factual findings, as well as the law as it is applied, specifically whether something would constitute reasonable or substantial emotional distress, whether there was legitimate purpose, and whether that's harassment, is a de novo standard. The trial court,
basically the trial court determined she's spraying her plants, she's fertilizing her yard, she's throwing her paint water into the grass. The court obviously did not believe that she's saturating her carpets, that she's basically rejected a finding that she was waging chemical warfare, because there was no indication that, you know, she had dogs, she had grandchildren. It just didn't believe that this was going on at the level being described. And to the extent it was going on at all, the legitimate purpose was maintaining her yard, you know, doing her painting, killing weeds, that kind of thing. So given that, where is the flaw in that? Either that factually that's not supported by competent substantial evidence, or legally that doesn't rise to a level of necessitating an injunction.
the factual findings of the trial court completely and utterly ignore the evidence that was presented through 8 witnesses and 2 expert witnesses. It fails to take into account the high levels. Judge Kelly, you're muted. I'm sorry.
I'm sorry, I didn't mean to interrupt your answer, but while you're giving that answer, would you also address whether the trial court specifically made any finding with respect to the medical evidence or the Department of Agriculture report?
No, she didn't mention it whatsoever in her final order. She didn't even reference it whatsoever. And more to the point, I've read her ruling numerous times, and not one word, nowhere in the trial court's ruling does she mention credibility. The word credibility is not mentioned whatsoever. The trial court's ruling completely ignores the testimony from witnesses who specifically saw this woman spraying chemicals over the fence. It ignores the Department of Agriculture's findings that there was insecticide found in the soil on the Barisic property, exactly where Ms. Frost was dumping these chemicals. Furthermore, it also ignores the high level of insecticides found in this woman's system, who the trial court actually did make a finding that the Barisics never use any type of chemicals on their property. It belies logic and reason to assume that this normal amount of chemicals that is being sprayed, and I would point out, over on the property, in addition to the trespassing, in addition to all the other things that this woman was doing to this poor family, culminates to the level of stalking. It is a direct harassment of next door neighbors. It's not just a neighborhood tit for tat that you see throughout the case law.
But let me ask you, can you refresh my memory? I know
Sure.
there are photos and I know there were cameras and videos. were there any videos that actually captured the spraying occurring?
There is, in terms of videos, I'm not aware of the videos. There is absolutely photographs of the
I
spraying.
think I saw some still photographs.
There's definitely photographs of the spraying. There are numerous photographs of the appellee, in this case, coming out of her garage and throwing some unknown substance onto the ground. Many times,
The police report that wasn't admitted into evidence, is that right? Am I
That's
right
correct.
about that?
you're correct.
Okay.
However,
Does the record show whether, just what's in the record, whether your client has ever sought to have the police address this issue?
yes, numerous times. Numerous
What's
times
the-
the police were called out.
And nothing happened? So just what's in the
Nothing.
record?
Just what's in the record, the police were called out numerous times and nothing happened.
Okay.
Within the record, there is a body cam footage, which is transcribed between an officer and Miss Frost. And at that particular time, Miss Frost is issued a trespass warning for going on the Brissicks property. And the officer also notes that her conduct is, quote, borderline harassment to the Brissicks. That is specifically found on page 230 of the record. And I believe that Miss Brisick, the appellant in this case, also specifically testified that they called the police numerous times to no avail. They called the Department of Agriculture numerous times to no avail. And it got to the point it was so bad after having issues with their health, including lung nodules and a collapsed lung, that they actually had to move out. And Judge Rothstein-Yoakum, in addition to all of that evidence and the photographs and the dumping of chemicals, we have testimony that corroborates and was completely ignored by the trial court that this incident of chemicals were happening. Multiple witnesses described a white mist coming over the fence from Miss Frost's residence and then becoming incredibly ill. In terms of case law that is similar to this instant case, I would cite this court to the Johnstone cases out of the 4th District Court of Appeal. Although not injunctions for protection against stalking, the issue was ultimately stalking. The first, Johnstone 1, involved a violation of probation, where the state had violated a defendant's probation because of stalking his neighbors. Very similar to that type of stalking, where the gentleman is putting his lawnmower over burning trash, and the fumes as well as the smoke goes into the neighbor's property, as well as dumping noxious manure, oil, and other things near the property, which inundated the house, is extremely similar to this case. It is an invasion by a neighbor into another neighbor's house of chemicals, which is specifically prohibited by Florida statute. There is no way that a trial court in this state can find that this was a legitimate purpose when what is being done is a violation of Florida statute, as cited by the Florida Department of Agriculture. Furthermore, in addition to the medical evidence, the Department of Agriculture, in addition to the witness testimony, which corroborated everything that the Brissicks were saying, you have at one point in the Florida Department of Agriculture report where Ms. Frost admits to spraying mothballs, which is illegal by statute, and she's actually cited for. Again, as the Johnstone case has demonstrated, the 4th DCA found that that was sufficient evidence to violate a defendant's probation, which, as this court knows, the burden of proof is by the preponderance of the evidence, which is similar to the burden here. The trial court repeatedly, through her final order, says that the Brissicks did not provide competent, substantial evidence of stalking. That's not the burden. That's an appellate burden that this court potentially looks at, not the trial court. So not only was the trial court confused as to the facts, she was confused as to the burden of proof necessary to establish stalking in the first place. And the Johnstone case, there was a second Johnstone case where it was an appeal from a conviction of actual stalking. Burden of proof there is beyond a reasonable doubt. The Fourth District Court of Appeal still found proof beyond a reasonable doubt under facts similar here. I'd also point the court to the Robertson case, which I cited in my brief. Judge Kelly?
Well, I was just going to let you know that you're at 15 minutes, but I didn't want to interrupt your point.
I'll reserve the balance of my time.
Okay. All right. Thank you. Mr. Wade?
Good morning, Your Honor. Zachariah Wade on behalf of the appellee, Ms. Beth Frost. I believe there are two issues to address here. The first being what is the applicable standard of review, and our position is that it is to determine whether or not the trial court's decision was based on competent substantial evidence. I want to actually start by addressing some of the points counsel made, not only in his argument, but also in the initial brief, because in the initial brief, there is a mention that Ms. Frost admitted in open court to spraying the Barisics directly. And I would point out that in the initial brief, there's no citation to the transcript or the record where that was said. And I would submit to Your Honors that that was not said. She did admit to spraying on her own property, but that is consistent with the photos that Your Honor, Judge Kelly may have seen where she's spraying on her own property. Specific to counsel's position that the trial court utterly and completely ignored the facts, the medical records, the Florida Agricultural Report, I would submit to Your Honors that that is not the case. Specifically, in issuing her ruling, the trial court said, having heard the testimony of the petitioners as well as their witnesses, having heard the testimony of the respondent, having reviewed all of the evidence, which would include all exhibits, which would include the medical records and the Florida Agricultural Report that's been presented by both the petitioners and respondent, and also having reviewed the memorandums of law that both counsel prepared, and having read all of the case law that was provided by both petitioner and respondent. So the trial court made it very clear that she took all evidence submitted into.
But she didn't make any specific finding one way or another about the medical records or the Department of Agriculture findings, did she?
I do not recall that she did, but the reason that she did not is because ultimately there was no connection directly between the substances that were found in Ms. Barisic's system and the chemicals that were found in a shed.
I thought the chemical that was in mothballs was found in her blood. That was one of the things that was found in her blood, is the chemical, one of the chemical components of mothballs. Is that not correct?
I believe you are correct, Your Honor. But what I'm saying, and I want to make sure you're done, but what I'm trying to articulate is that while that was found in her system, and while there was an old jug of mothballs found in the shed, there was no description of how that actually happened. And I'm going back to the fact that no one has ever seen Ms. Frost spray or throw these chemicals onto their property.
Maybe I'm mistaken in my recollection, but I thought she did admit to using mothballs, to throwing them out in her yard. I thought she did admit to that.
Yes, Your Honor, in her yard. The position that counsel has taken is that Ms. Frost has initiated a chemical attack by dumping and spraying. And
right. No, I understand. She didn't admit that she threw them or sprayed them at the appellants, but she did have mothballs and she did use them.
On her property, yes, Your
Right,
Honor.
right.
Mr. Wade, going to the medical records, as I've looked through the record, I don't see any baseline records. Am I correct?
You are correct, Your Honor. Those were not submitted, only the reading at the time.
Okay.
So continuing on, while the trial court may not have made a specific finding, and it is our position that that is based on the assumptions that the appellant had made throughout the entire case, So there was no direct finding made because of that. There was the ability to make that finding was not presented to the trial court because they were just given a set of medical records, as Judge LaRose said, without a baseline. So we don't know what the distinction was. And I would also submit that there was no follow-up. There was no follow-up appointments. And I asked that question directly. There was no continuing care that was needed to address these. It was one blood test that showed a substance, and the appellant's testimony as to where those substances came from. And my position is that that prohibited the trial court from being able to make that ruling. But I would like to continue on as well, because I believe that the main issues are the standard of review, and then the second issue, which is whether or not competent substantial evidence was heard. So one of the main cases that Mr. Crawford has cited to in his argument in terms of the standard of review is Pickett. And Pickett is a case where neither party was represented by an attorney. It was a fairly basic injunction hearing where both parties provided their testimony, but no real evidence, witnesses, reports, or anything like that. At the appellate level, the court said that decision was not made based on competent substantial evidence because there was none. Turning to the case at hand, as Mr. Crawford has said, there have been 8 witnesses, 24 exhibits, 9 hours of a hearing that was spread across 2 days. And I would submit that the period of time that this entire case lasted was 3 months. So the position that the appellant has taken is to say that the trial court did not refer or base its decision on competent substantial evidence without addressing the fact that it was their evidence that they put on. As Mr. Crawford stated, the only witness who testified for the respondent was Ms. Frost herself. All of the other evidence, the multitude of it, came from the appellant. And I think it is hard pressed then to turn around and say that that is not competent substantial evidence. The definition of competent substantial evidence is listed in the case I cited in my brief, Duval Utility Code v. Florida Public Service Commission, that says competent substantial evidence is evidence as will establish a substantial basis of fact from which the fact at issue can reasonably be inferred. We heard a lot of testimony from individuals related to the family who indicated that they would come by and smell something, and that it would upset them and that they left, or that one individual was doing work in his garage, and while he's grinding metal, he smelled something that he believed came from outside over the fence. After hearing all of this testimony, the trial court's reasonable mind concluded that these folks were providing information that was not substantial enough to enter an injunction. And our position is that she got that right. To find that the trial court abused its discretion, or not an abuse of discretion, excuse me, to find that the trial court did not apply the proper standard of review in this case, the appellant would have to show that its own evidence was confusing or convoluted. At no point did the trial court indicate that she was confused by the testimony, that it was so convoluted that she did not understand any of it. She quite literally listened to it, and I submit to you that she didn't believe some of the testimony that was presented to her. If I can have just a moment to review my notes. Counsel stated in his argument that the egregious nature of these allegations should not have been, as he said, ignored by the court. And one of the manifestations of that he noted was that the Barisics moved out of their own home, that this was such a substantial interference to their daily lives that they had to abandon their home. And I would submit that the petition for an injunction was filed in February, and they indicated that they had moved out before then. The final hearing concluded in March, and they had still not returned to their home. And when asked about that, they had no explanation as to why, other than their fear that these attacks, as they've described them, would continue. And I would submit, and I present that to you to articulate the level of unbelievability that was laced into the testimony of each of appellant's witnesses, because if they were truly afraid, they're saying that they just couldn't go back home. But this was an instance where the police had been called. If these allegations were true, Miss Frost was essentially called out, right? The attention was on her, and they just maintained that as soon as they got home, Miss Frost would run outside and start spraying them in the face, which is the allegation that was made. Not that they were just being misted over or fog was touching their property, but that Miss Frost was coming outside and spraying them directly in their face. What's more is that they were saying she would spray them from outside of her window, standing on the windows of her home, which is
I
not.
thought she sprayed it on a carpet and then directed a fan to the carpet.
That was also an allegation that she
So
saturated.
how do you, you're losing me on the fact that they didn't move back. Doesn't that tend to prove that it did happen, that they are afraid?
No, Your Honor, I mentioned that because to satisfy the burden of proof to obtain the injunction, the appellants had to show an ongoing course of conduct.
Oh, so they, in other words, they have to continue to subject themselves to poisoning.
No, ma'am, I'm taking the position that there was no poisoning, and they were
Well, but
not.
from their perspective, there was.
Yes, ma'am. Yes, Your Honor.
So so they would have to continue to subject themselves to that in order to be entitled to an injunction?
Or concede that these attacks, as they have described, are not as substantial or not even truly in existence. They would have to have admitted that they were not being truthful.
Okay.
So in sum, the trial court did base its decision on competent substantial evidence. And the standard of review that should be applied is whether or not that was done. Our position is that it was, and I have no further argument. Thank you.
Okay, thank you. Okay, Mr. Crawford, you've got your 5 minutes.
Whether the standard of review is de novo or whether the standard of review is whether or not the trial court's factual findings are supported by competent substantial evidence makes no difference. Under both standards of review, the appellant should be entitled to reversal. In order for something to be competent and substantial, the case law authority says it's got to comport with reason and logic. It is absolutely illogical and unreasonable to assume that regular spraying in a yard of pesticides would cause somebody's levels, as demonstrated on the blood test, to be sometimes 95% above average or 75% above average.
Yeah, but Mr. Crawford, my concern with the medical evidence is that we have no prior medical records that give us a baseline as to your client's health.
But Your Honor, there's not baseline medical records. However, there was expert testimony from 2 witnesses who specifically said that those levels are extremely high. We also have evidence, the trial court made a factual finding of, that the Brissicks don't even use those chemicals. So whether or not there is a baseline is immaterial, I would submit, because you have expert testimony saying what those levels mean. And you also have a finding from the trial court that says they didn't use those chemicals. Furthermore, you have the chemicals, you have the blood tests, you have the tests from the Florida Department of Agriculture, which establish that this was taking place. You have corroboration from witnesses, you have direct testimony, you have medical testimony, you have testimony from the Florida Department of Agriculture. Specifically, as it relates to the de novo standard of review, I'd cite Pickett versus State, 236, 1142, both of which say that substantial emotional distress and legitimate purpose, a court looks to the de novo standard of review. Just this year in October, there was the Potts versus Lewis case, which Judge Kelly, I believe you wrote, which specifically says that whether an action's caused harassment is reviewed by the de novo standard of review. It is not competent substantial evidence. But as I said, even if it was, the trial court's ruling does not comport with logic and reason, which is required according to the case law. I'd respectfully ask the court to look to the Johnson 1 and Johnstone 2 case, which found under similar circumstances that the evidence was sufficient for stalking by the preponderance of the evidence beyond a reasonable doubt. In this case, you have testimony from 8 witnesses, 2 expert witnesses, numerous photographs, as well as video evidence. The Brissicks called the police multiple times. Nothing happened. They called the Department of Agriculture. Nothing happened. They were left with no choice except to file a petition for protection against stalking. In terms of making any assumptions, there is direct testimony about spraying the chemicals over the fence. There's photographs of chemicals being dumped over the fence. There's testimony of repeated trespassing. I'd respectfully ask that the court reverse and remand for institution of an injunction against Ms. Frost. Unless there's any other questions, again, would ask the court to reverse.
Thank you, Mr. Crawford. Thank you both. This concludes our docket today, so court is adjourned.